Welcome to the Spiggle Law Firm podcast. I'm Tom Spiggle, the founder of the Spiggle Law Firm. In this podcast, we help people who've been fired or afraid that they might be and discuss cutting edge legal issues in the news. Today, I'm thrilled to be joined by a repeat guest and always a favorite, Louise Ryder, who has many years of employment law experience, in particular with federal sector work. So today we're going to be continuing our series in federal sector litigation. If you haven't seen our previous podcast on this, you might want to check those out if you want a chronological order of these things. Today, we are going to be talking about the report of investigation, or the ROI, which is a big component of this, and we're going to give you tips and tricks on how to analyze it. But before we get started and start getting some of Louise's considerable expertise on this, just a little bit of the fine print, because lawyers, but this is not intended to be legal advice for you. It is only for educational purposes, nor does it create an attorney-client relationship with the Spiggle Law Firm. If you want either of those things, you got it. You should go hire a lawyer. So welcome again, Louise.
Hi, Tom. It's good to see you again.
Great. So let's just jump right in. So let's start by telling folks who are listening what an ROI is and where that comes in the process.
Got it. So an ROI, or report of investigation, is and some agencies will call it the investigative record instead. It's essentially the summary of what has been compiled during the investigation stage, or the formal complaint period. So essentially, the agency will have an EEO investigator, who can sometimes be an independent contractor, conducting an investigation where they will, as we described last time, they'll get information from you, the complainant, and they'll get information from other witnesses, including the responsible management official. So all of that information, what you have submitted and what the responsible management officials have submitted, is going to be included in the report of investigation. Now, the report of investigation, it's usually structured where at the beginning it'll have the formal complaint that's been filed, as well as the documentation from the informal stage, meaning that the EEO counselor during the informal stage will write up a report. And that will outline when you reached out to them, what claims you described to them during the informal stage, and some other matters like that. The formal complaint will then be included, as well as the acceptance letter. We had discussed that briefly last time, but essentially that's where they indicate they accept your claims or reject them, and any objection you may have submitted will be included as well. All of those are key documents that when you're reviewing an ROI, you're going to want to make sure you check the date that the EEO counselor indicates that you have initiated EEO contact, because sometimes that's the date when you filed your informal complaint, which might be in there, but sometimes you initiated contact a few days earlier. And in that case, you're going to want to make sure that they have accurately identified that date, or that you have documentation of it somewhere. If you reached out to them by email a few days before and they indicate that the first day you initiated contact was when you submitted that EEO form a few days later, it's important to keep your records, because that can be important when it comes to determining which claims are timely down the road.
An important point that we touched on last time as well is there are no lawyers involved, except maybe your own, but there are no lawyers involved up to this point, right? So you're dealing with a contractor, like you said, who may be a lawyer and who may not be, who is charged with coming up with this report of investigation. Is that right?
Yes, that's correct. Generally, sometimes they will employ attorneys for the EEO investigative period, but to be those investigators, but it doesn't happen very often.
And so I guess one of the imports of that, and correct me if I'm wrong here, is that this is not typically a place where you settle a case, right? They're just pulling together the investigation. This is getting all the records there. You're not going to getting offers of settlement. Like that might happen at the very beginning of the process and later when you get in litigation. But this stage is sort of a dry period now, at least in terms of potential settlement.
Mm-hmm. Well, and this stage is, essentially after you get the ROI, what you're doing is you're going straight to the EEOC or or requesting a final agency decision. And we're going to be delving into the pros and cons of those a little bit later. But reviewing the ROI, there are specific considerations you want to keep in mind when you're reviewing the ROI in terms of assessing the strength of your case and knowing where to look and what the key documents are.
Got it. So you want to go through, you want to look at when they say you filed, you filed your first, you started the process. And then what else? Let's say I don't have a lawyer at this stage. What else am I looking for in the ROI?
Well, you're going to want to look at the acceptance letters and make sure that any objection letter that you submitted is included. So that's something that if it wasn't, that's something you're going to have to address down the road, because you want to be able to prove to the administrative judge at the EEOC, once you get there, that those claims that you raised them, you objected to their dismissal, and that those issues were previously addressed. Then you're going to want to review what is in the app. Presumably, you know what's in your own affidavit, but you're going to want to review the affidavits of the responsible management officials if you haven't already, and assess what information in there you can prove to be false, as well as go through additional witness affidavits. So usually there will be additional witnesses who the EEO investigator reaches out to and gets affidavits from. And those can be witnesses you've suggested. It can also be witnesses that the RMOs have suggested. And so it's often very important to see what additional information there is in there. Then you're going to want to review what documentation has been attached to each of those affidavits. Because a lot of the time a responsible management official will attach documentation that they believe supports their iteration of the facts. And so if, for instance, there are new documents that you've never seen before, if the RMO, sometimes he or she will have notes that they take after counseling meetings, or memos to record, or emails between themselves and their supervisor or themselves at HR. Those documents can be very relevant and can contain information key to your case. Sometimes there'll be documents that you want to look at to know what their depiction of the facts is. If you're seeing their memo to record, you're going to want to see if that reflects your recollection of the meeting, or if there are inconsistencies, false statements, what you're going to be able to respond to. And you also may want to look for documents that will help you. Potentially communications between them and HR, maybe where even sometimes HR will produce as a part of their affidavit documentations with the RMO where they indicate that, say, they don't agree that the RMO should do this action. Now, that's not often produced. Usually you're going to have to wait till you're going to have to pull that from the agency kicking and screaming through discovery. But sometimes it's in there, and you want to find those documents that are going to help you. Also depends on the type of case as to what documents will be included.
And so, I mean, it sounds like so potentially, I mean, this could be a gift box to some respects for you, the employee, because there could be some really good stuff in there for your case. And as we discussed, I think last time, I mean, these can be substantial. I mean, they are like a book. They can be hundreds of pages when you include all the exhibits. So these are pretty substantial pieces of work product. So I think it is important. You know, we see this in all kinds of litigation, but I think it's certainly probably true here that sometimes the other side's not even aware, or they haven't closely reviewed some of their own documents. And so you may find something in there. It sounds like they could be a real help to your case.
Mm-hmm. And the other documents to look for are going to depend on what type of case it is. If it's a case involving a disciplinary action, a suspension or proposed demotion, removal, then you're going to want to make sure that what they have in there includes the proposed discipline, your response, and the decision, as well as all supporting documentation, because a proposed disciplinary action should have all the supporting documentation with it. And you're going to want to make sure that that's in the record if you're dealing with a disciplinary action. If you're dealing with a non-selection action, there are very specific documents, probably more so than any other type of case, that you want to make sure you look for.
When you say non-selection case, what do you mean?
A non-selection case is when you're alleging that you were not selected for a position or a promotion, and because of your protected class, so because of your race, your sex, your disability, that you were passed over in favor of someone who is less qualified than you in for that position. And there are different types of that. Sometimes it might not be the standard non-selection. Sometimes you might be dealing with a situation where you're alleging that the position was written with someone else who's less qualified in mind, someone outside of your protected class. So that's a less common but occurrence that comes up on a fairly regular basis, and the documents you'll have are slightly different.
So when somebody, and I presume this happens in your practice, people will be representing themselves up until this point, but they've gotten the ROI. They realize it's a huge document and they may need help with it, and they come to you. I mean, are you doing your sort of reviewing for the things that you have said? What else are you looking for, as an attorney coming into a case at this stage?
That again will depend on the type of case we're addressing and what the burdens of proof are, what the frameworks are, the prima facie case. And if we're dealing with a non-selection, for instance, I'm going to be looking at whether or not they have all the relevant documents in the report of investigation and what documents I might want to ask for if they are missing. So non-selections, you're going to usually want to make sure that you have the selection procedures in there, the agency's policies and procedures and guidelines for how they process selections. For instance, some agencies, they usually have a separate panel that will review resumes. And so if that's the case, you're going to want to make sure that you have the documentation from the panel who reviewed resumes and what each panel member said, what their determination as to the resumes were, what their evaluation of the resumes were. You're going to want to make sure you have the applications for your client, the individuals selected, and who else is going to depend on where your client was cut out of the race. So if your client was found to be ineligible for the position, you're going to want a lot more individuals, applications, resumes, job packets. If your client got through the first interview and was then not selected after that, then perhaps you can limit it to just those individuals who were interviewed in the first interview. But you're still going to want to make sure you have those documentations of the resume review determinations, and then separately any documentations from evaluations of the interviews. And so that should include the rankings, each interview panel members' ranking sheets, as well as any separate notes that they have. And those key documents, they're very standard and they should be included. And so if they're missing, that's absolutely the first thing you're going to want to ask for in discovery. And the first thing that before the judge you're going to want to mention is missing.
So you don't get a second ROI, right? You don't go back to them and say, hey, we need this information. That's something you're looking to get in discovery at a later date?
That's correct. You can't have a second bite at the apple unless the judge orders it, which every now and then comes up. But those are the arguments that you'll make to the administrative judge as to, one, sometimes you can file a motion for sanctions if the ROI is very deficient. That doesn't come up a lot, but sometimes it is appropriate. Most of the time where it's relevant is just what documents you need to supplement the record with in discovery.
So I'm just curious, what do those sanctions look like against an agency?
Usually the ROI will have to be very deficient for that to come up. For instance, I had a case once where one of the claims was a disciplinary action, and the ROI didn't even have the proposed disciplinary action or the actual disciplinary action in it. So that was pretty extreme. Those are basics. If you're dealing with, you were demoted, you'd think that the actual proposed demotion and the decision to demote you need to be a part of that record.
Right.
And usually it's going to be somewhat minor sanctions that the judge will give, but they can be important ones, such as an adverse inference. So if there are certain documents that were excluded, you can try to argue that the judge should find that those documents, essentially make a determination that had those documents been included, they would have been in your favor. Now, you're not going to get those sanctions very often, because most of the time what the judge does is just order the parties to supplement the record, to provide information and discovery. Usually there's no detrimental effect on either party as a result. But you can argue that there have been delays. What judges are more likely to do is to offer an award of attorney's fees for you seeking those documents that should have already been included in the record.
So we've got some non-selection. Are there kind of other broad categories of cases that you see that would affect what documents you're looking for?
I mean, with adverse actions, it's about the adverse action. You're going to want to get those. Non-selection is very specific as to what documents there are. If you're dealing with more of a hostile work environment claim, there's not a specific category of documents that you're going to expect or that the agency usually should be expected to already have, other than, of course, the affidavits and anything that the RMOs want to include as part of their affidavit. You can certainly indicate during the formal stage that you think XYZ documents are relevant and should be requested, but there's not a specific iteration of documents that I would expect for hostile work environment claims.
So we were talking about like other documents that, for example, a sexual harassment or a hostile work environment, if there are other specific documents. It sounds like, non-selection is one where there are specific documents, but that for these other claims, particularly like, let's say hostile work environment was the example that you used, there's not a particular category of documents that you're looking for. Yes, you're looking at documents that are relevant to the case, but there's not the same specific documents you're looking for. Is that right?
That's correct. I mean, there are certainly documents I would ask for, and especially hostile work environment emails are going to be key. But the agency almost never produces emails, it never does a search for emails in the investigative period. Generally, what they would do is just produce whatever emails the RMO has volunteered to provide. So those would be just ones that usually help them. So that is one of the reasons why discovery is very important. So depending on how important that email correspondence is to the case, discovery can be more or less necessary.
I think that's an important point, particularly for folks who may not be working with an attorney. Like, don't take the ROI at face value, right? I mean, there could be a lot of documents that the agency, doesn't produce that can be very helpful to your case. And so you don't get those until you go into the litigation process. So if you look at the ROI and it seems to you that there are holes in it in terms of the documents that are provided, it are probably holes there, that the agency has relevant documents or relevant testimony that it hasn't produced, but you can get those when you go through the discovery process later in litigation.
Mm-hmm. And another common hole would be communications between HR and the RMO, as well as different drafts of proposed disciplinary actions. None of that is usually produced as a part of the report of investigation, but it can be very important. If you get the RMO sending a draft to HR that says, she is terrible, I don't like something that is particularly egregious that indicates their distaste for you. For instance, in a case where you're dealing with disability discrimination, if the RMO is emailing HR and saying, she's just out of work too much, I don't know what to do, I don't want to have her responsible for all these things because it's too much work for me to figure out what to do when she's on leave for her disability. Obviously, they're not going to word it that way, but that's going to be pretty important evidence for a claim of disability discrimination. You can say that, well, look, she sent me this demotion because I was out of work due to my disability all the time. And you can prove that by the contemporaneous emails between HR and the RMO. So that information is also key and not included in the ROI a lot of the time.
Yeah, and it sounds like the ROI also gives you a pretty good roadmap for what to ask for in discovery. Like you just mentioned, which I hadn't thought about, but makes sense. Like you're entitled to see drafts of the disciplinary. Like what did they? And we've seen this before in other cases where a defendant will put offending language like illegal actions, and then somebody will realize it, and then they'll take it out. But it's
Hmm.
still relevant to what was your employer's state of mind, or the responsible official state of mind when they made this when they took this action. So again, a good roadmap, you're not going to get it all necessarily in the ROI, but then when you go into litigation, you could say, hey, here's this, they produce this document, about my discipline, but I want to see all the previous drafts.
Absolutely. I think those are the
ROI?
key things I would look for in the ROIs. I mean, documentation or testamentary evidence that support each of the elements of the claim you want to make. And that does differ depending on the type of claims.
Yeah. And I think that's why you said like one of the key documents are the accepted claims, are they all in there, to really use that as sort of a guidepost for everything in the case. Every piece of information, it should be relevant to one of those claims. That's why it's important to get the claims right. But then to, go through the ROI in a very workmanlike fashion, to make sure like, hey, what documents are relevant to my claims and what holes are there that I want to ask for that information when I get into litigation. It's a good but incomplete roadmap for you going forward.
Hmm. And without getting too much into the legalese, the whole time, you want to keep in mind that prima facie case. Because, I mean, you need to, if there are documents or testamentary evidence that show that you were treated less favorably than your similarly situated colleagues outside of your protected classes, meaning if you're alleging race discrimination, your colleagues outside of your race or sex, the same thing. So just always keep that in mind, that legal framework, when you're going through the ROI.
Yeah, I think that's a great point. And just for those who aren't burdened by a law degree, the prima facie case is sort of like the basic elements, the basic building blocks you need to make the case. And it's sometimes even experienced practitioners, you can forget about that because you get so into the weeds and the tone of what was said here and there and the he said, she said. We all can get involved in that, and those can be important details, but it all comes back to, can you prove the essential elements of your claim, which is the prima facie case.
Absolutely.
Well, this has been great. Anything else you want to add on ROIs?
I think that's it off the top of my head.
Okay, great. Well, I'm going to let you jump off while I say goodbye to our audience. But thanks again, Louise. This has been, as usual, a tremendous help. I think folks that are staring at a big fat ROI will get a lot of great information about this.
Thank you. It's been a pleasure. Have a good day.
Okay, bye bye. Thank you so much for joining us here on the Spiggle Law Firm podcast. I hope you learned as much as I did about the ROI and how an experienced litigator looks at that as both a springboard that you can use for your case and also as a guidepost for what information you don't have that you need to ask for in litigation. If you'd like more of this kind of information, you can go to our site, the Career Rocket .io, and you give us your email, and every week we will give you the latest and greatest in employment law and other tips and tricks on how to keep your career on an upward trajectory. If you found this podcast useful, please feel free to share it with a friend. We're trying to get the word out to as many people as possible. And I invite you to check out my new book, Fired or Afraid You Might Be. It's available on the website. You can also get it on Amazon through Kindle for $1. So go check that out. I really walk through kind of the steps that an attorney uses to evaluate a case and how to decide whether and how to move forward. So I hope you found all that helpful. Wishing you all the best, and we'll talk to folks next time.